Throughout June and July of 2013, headlines across the world have been full of the story of Edward Snowden, the former National Security Agency contractor now on the run from his former employers and giving out data and information on how the US surveillance projects have been run throughout the world, especially projects that are now familiar to everyone, such as PRISM. Efforts to gather metadata from emails and communications sent electronically throughout the world. Now, the Edward Snowden case gives us a great prism onto the interrelationship between law and the security agencies. Effectively, in this case, we're starting to see the effects of the privatization of national security. Now think about it, national security used to be the core function of the state. No matter what else the state did, it and its own agencies, say MI5 or MI6, would be responsible for maintaining the security of the state. Without security, governments would say, then people wouldn't be able to go about their day-to-day lives. It was about providing a sufficiently secure environment to let ordinary day-to-day life continue. The basic fundamental function of government. Well, now in the 21st century, we see someone like Edward Snowden come in who isn't a member of the CIA and isn't a member of the FBI. They're instead an external technical contractor, brought in because the costs of gathering this information, the costs of having this level of technical expertise are so high that effectively states want to subcontract this job out rather than maintain staff like this within their agencies. Now the problem for a state is that means that someone like Edward Snowden, or say a low-level worker like a soldier like Bradley Manning, has much less institutional buy-in to the operations of a security agency than, say, a full-time member of the National Security Agency, the FBI, the CIA, MI5 or MI6. Now, what that means is these individuals with much less institutional loyalty are much more likely to leak information on projects that they believe to be morally dubious into the public domain. Now that's where law comes in. So just at the same time as we've got an increasing number of leaks about states and their activities coming through organisations like WikiLeaks, we're seeing that it's very difficult for legal remedies to begin to redress issues that have been exposed by those leaks. Now, if you like, the European Convention on Human Rights is where most lawyers would go to look at finding redress for an abuse like unauthorised state surveillance of an individual. And in the European Convention, Article 8 provides for a right to private and family life. But there's where the problems start, because this right isn't an absolute right. It's a qualified right, which means that it can be justifiably restricted if three conditions are met. Firstly, there must be a public interest which outweighs the human right in question. Secondly, the restriction on the right must be prescribed by law. There must be lawful authority for pursuing that public interest. And thirdly, the restriction on a right must be necessary in a democratic society. In other words, the State Security Agency, in a case like the PRISM scheme or the UK Security Agency's equivalents of it, can't do more than is necessary to answer the requirements of the public interest. So let's take a look at those three requirements in turn and see where law's problem with dealing with a project like PRISM or the GCHQ's surveillance of communications comes into being. Firstly, the interests of a democratic society? What is the public interest that we have to weigh against an individual's right to privacy? Well, built into Article 8 of the European Convention is the idea that one valid public interest for restricting the right to privacy might be national security. And government's arguments, even before events like September the 11th and the era of mass casualty terrorism that began in 2001, were that government needs particular leeway in dealing with issues like terrorism. So effectively, government wants the space to be able to survey individuals and try to prevent terrorist attacks before they happen. Now, the problem for law is that the courts are not experts in weighing up and carefully deciding upon relative intelligence data and whether it's pointing towards an attack. So often, on that criteria of the Article 8 test for justifying the restriction of a right, the courts have given government almost a get-out-of-jail-free card. They've allowed government an awful lot of leeway in identifying a particular interest as a national security interest and which therefore weighs against the right in question. The second important factor under the European Convention is that there has to be legal arrangements in place setting out how that interest is to be balanced against the human right in question. And in that regard, government in the UK have the Regulation of Investigatory Powers Act 2000. Now that is an incredibly broad statute. It allows government to intercept through the Government Communications Headquarters, GCHQ, any communication which starts in or ends in the United Kingdom if it involves a transnational element. Now think about it. Every time you do a Google search or a Yahoo search, you're sending your search engine terms to a search engine whose servers are based outside the UK. Every single one of those searches is a transnational communication. And that means all of them are potentially subject to the Regulation of Investigatory Powers Act power to intercept information. Now, government can't go into and look at every single email communication, every single search engine term that's being used across the internet. Instead, what it's doing is running complex algorithms to try and spot keywords or phrases that it thinks might be linked to terrorism. What we're talking about here is metadata. The overarching arrangements, who's sending emails to who, straplines, keywords within it, rather than a careful review of every single email. Which brings us on to the third criteria. Because government, if it has a good public reason for abridging a right, and secondly, it has a legal authority for doing so, no matter how broad that authority might be, must also justify that authority as proportionate, must do no more than is necessary in restricting a right, and secondly, must maintain adequate safeguards over the operation of its restrictions. Now, in this regard, surveillance and intelligence gathering in the 21st century, in the internet era, differs directly from what might have been happening in the middle, say, of the 20th century. In the middle of the 20th century, if you wanted to survey one person and their communications with others, you might have to put a tail on them. You might have to stop and search them on the street. You might have to arrest them and put them under questioning. You might also say bug them or physically tap an individual's phone line. But all of those modes of surveillance involve intrusions into an individual's life. Whereas today, with the harvesting of metadata, there is no demonstrable intrusion into someone's activity. In that you're not stopping them in the street, you're not stopping an individual from going about their life and holding them for as long as you can search them. The thing is, if the level of intrusion is so low, when it comes to harvesting metadata, the requirements of the European Convention for adequate safeguards and proportionality of response are very easily met by government. If you like, the safeguards that would need to be in place if you stop someone in the street for seeing is that power being used justifiably are much greater than any safeguards that would be needed as to harvesting metadata. So, to sum up, we've got a conundrum regarding law. We're seeing, if you like, a disjuncture in what was once known as the public-private divide. Suddenly, private actors like Edward Snowden are increasingly involved in the gathering of intelligence data in states' most intimate security projects. And as we've said earlier, that makes it much more likely that information is going to leak or be leaked by these individuals when they don't like the nature of the state's activities. It's much more likely that potential abuses of power are going to come to public knowledge. But at the same time, it's less likely that those potential abuses of power are going to be subject to legal redress. And why is that? Well, effectively, the traditional basis of a document like the European Convention on Human Rights, the theories that underpin a liberal democracy, require justification for state intrusions. And they require higher levels of justification the higher an intrusion goes into someone's life. The harvesting of metadata involves very little physical intrusion into someone's activities. The challenge for law is therefore, how do we recast our understanding of human rights to curtail abuses of power in those circumstances? Thank you.